Hi, my name's Mike Heinum, and I'm an attorney with Heinum Law in Harrisburg, Pennsylvania. We're located at 2608 North 3rd Street. Today I'd like to talk to you a little bit about contracts. I know anytime someone puts a contract in front of you, if you're not familiar with dealing with contracts or reading the terms and conditions, it can be a little bit daunting. And so many times, if the contract is something for other than just a simple consumer purchase like a car or something of the like, it's a good idea to consider consulting an attorney to review the contract with you. There are many things to consider when you're looking at a contract, such as what is the offer, what acceptance was made, or was it a conditional acceptance, and what consideration was made in return for the contract. Those are generally the three most commonly referenced parts of a contract: offer, acceptance, and consideration. For any contract to really be valid, there has to be some type of consideration, meaning that there's some kind of bargained for detriment. I contract with somebody to perform a service. Their service is their detriment because they take the time to do the service. My detriment is I take the money out of my pocket to pay them. If you don't have proper consideration, you're probably many times not going to have a valid contract. There can be a contract that is formed even if it's not in writing. They're oftentimes called oral contracts or implied contracts. And oftentimes they're indicated by things that are considered such as substantial performance. For example, if I hire somebody to come and cut my grass, and we don't put it in writing, but they come to the house and cut my grass, and 75% of the way through I say, "Oh, stop, stop. I didn't want you to cut my grass." Well, you know, there's good evidence there that we had an agreement for me to pay that person. Otherwise, they would never have come over and spent the time to cut the grass. So when I talk about substantial performance on an oral or implied contract, that would be a good example of that kind of an issue. There are many other things that you have to look at, such as when the contract starts, when it ends, what is to be performed under the contract. Are there things that are going to have to trigger performance, such as certain dates, or like with a construction contract, you know, you're not going to put the siding on the house until the structure of the house is substantially complete. So there are many parts to a contract other than just the offer, acceptance, and consideration that are important to note. And it's very important to note as well what is going to be your ultimate cost. And it's important to sit and look through a contract with an attorney, because sometimes there are things embedded within contracts that you're not aware of that could come back to haunt you, such as the contract may, if there's a dispute, you may have to go to a different state to enforce your rights. Sometimes there are arbitration clauses in contracts which say you have to arbitrate, as opposed in which you give up your right to go to court. So there are many things to look at when you're entering into a contract, and if it's significant or substantial enough in terms of what you're risking as far as obligations or monies that are going to be expended, it's a good idea to really sit down and really understand what it is you're getting into. For information on this topic, please feel free to go to our website, www.heinumlaw.com, or give me a call at 717-774-1357. Again, this is Mike Heinum in Harrisburg, Pennsylvania. I'm an attorney with Heinum Law. Thank you for watching.